Morning, everybody. It is Wednesday, the 7th of October 2020. This is the licensing subcommittee of the Royal Borough of Kensington and Chelsea, and we're meeting to consider an application by the Chelsea Food and Wine Company Limited for a variation of the premises licence in respect of Chelsea Green Food and Wine in 20 Cale Street, Southwest 3. My name is Greg Hammond. I'm Councillor for Courtfield Ward, which is the ward immediately to the north of Stanley Ward, where the venue is situated. I've been to see the site from the outside because I wasn't familiar with it, but I have no interest to declare. I'd like to introduce the other members of the committee, please, starting with Councillor Healy.
My apologies, I was on mute. I'm Councillor Pat Healy. I represent Dalgarno Ward, which is in the north of the borough. I have no knowledge of this company at all and have never visited.
Thank you. Councillor Spalding.
Thank you, Chairman. I'm Councillor Malcolm Spalding, Councillor for the Earls Court Ward. I don't have any interest to declare, but I understand there's been from the applicant a representation that I spoke against an application as an objector to a committee a couple of weeks ago of a company called Earls Court Food and Wine, and I had no idea that that company was linked to this company in the hearing today, Chelsea Food and Wine. And so in the interests of fairness and transparency, Chairman, I'm prepared to stand down from this hearing, although I do feel that it's stretching the concept a little bit, so that if one objected, say, to one branch of Tesco's on a particular application, that wouldn't prejudice one against sitting on another application in a totally different area with totally different hours and so on. But in this case, since the applicant has pointed it out, I'm quite willing, with your permission, Chairman, to stand down this morning.
Thank you, Councillor Spalding, and we will stand you down in the interest of being ultra cautious in this case, but thank you very much for attending today. You're released, in which case Councillor Healy and I, because the quorum for this subcommittee is 2 members, Councillor Healy and I will carry on and decide the case between the 2 of us. It does mean that if we have a technical failure of any sort, we're relying on getting both of us back in the hearing for all stages, and if one of us drops out permanently, the hearing will have to be adjourned, because we must have 2 of us in the room at all times to continue. So Councillor Healy and I are the decision makers, but we are assisted by a number of other members present, starting with our legal officer.
I'll disappear, Chairman.
Thank you, Councillor Spalding.
Good morning, Chairman. This is Lindsay Lemazurier, legal officer. I'm present.
Thank you. And we have a licensing, we actually have 2 licensing officers today in turn, please.
Good morning, Chair. Paul Phelan, licensing.
Good morning.
Good morning, Chair. Fiona Johnson, licensing.
Good morning. And the committee is assisted by a number of governance officers. I won't ask them all to introduce themselves, but Martin Carver, Leonie Hill, Yasmin Yama, Esme Shari are the ones I see on the list. We have no responsible office authorities present today, and the applicant, if I could ask the applicant's representative to introduce yourself and your team, please.
Good morning, Hammond. My name's Thomas O'Maloin, and I'm the solicitor representing the applicant. And with me virtually is Mr. Rehan, who is the operations director, and I think he is live and will be able to introduce himself as well.
Thank you, Mr. O'Maloin. Mr. Rehan.
Hi, this is Shah from Chelsea Food Wine. I'm a director of the company. Thank you.
Thank you very much. And representing the objectors, Councillor Pascal.
I'm Councillor Will Pascal. I'm one of the local 3 Stanley wardens, councillors, and I've been asked to represent the 3 of us, but also the local residents in objecting to this application. I've been a councillor for 10 years, and I have nothing to declare in respect of this application. Thank you.
Thank you very much indeed. We were expecting a second objector who's registered to speak, who hasn't appeared yet.
If I could say one thing, there was I think it only happened once, but there was one piece of documentation in relation to this hearing, which actually talked about Thursday the 7th. Now, that obviously is impossible because today is Wednesday the 7th, but I just hope that Sir Paul Lever has not been misled by any of the documentation that went out. And I'll let you know that I've emailed him and asked him to get in touch with Leonie if he's having difficulty with getting in, and I've given him her mobile number so she could watch out for that.
Thank you very much, Councillor Pascal. That's very helpful. For everybody present, there's a few ground rules for doing these hearings online. If I could ask you all to only or to mute your microphones, please, and only unmute when you're called to speak to prevent any background noise. And please also turn off your cameras to save the bandwidth, except when you have a speaking part in the meeting. Final ground rule is that there is a chat function on Microsoft Teams, but it's not being monitored and we don't use it as part of these hearings. So this is an oral hearing only. We have a number of documents, so to do a document check, Exhibit 1, I'll call it, is the main hearing bundle. It consists of 57 pages, but I'll warn the parties that the version I'm using, which is a hard copy, isn't paginated. We then have an extra submission from the applicant, which came by email on last week. That consists of 5 pages, and I'll call that Exhibit 2. And then we had an email which we've admitted, which we'll call Exhibit 3. It's an extra objection. It's anonymous, consisting of 4 paragraphs that arrived yesterday. And having seen that Mr. O'Mayloin wasn't going to submit an objection to it, we've agreed to admit that, and we have read that. So we've read all of those documents. We don't need anybody to repeat the contents for us, but please do take us to any relevant sections when you're making your various cases during the morning. So the outline of the meeting today, in a moment I'll be asking the licensing officer to outline the case. I'll then give the applicant up to 10 minutes to present his case. That'll be followed by questions from the members of the committee, the legal officer and the objectors. And I'll then reverse the position and give the objector up to 10 minutes to present his case. And that'll be followed by question time. We won't have a summing up. I'll hear some advice from the legal officer and some detailed discussion of any conditions, if that's appropriate at that point. And then we'll adjourn to consider our decision. So are there any other preliminary matters from the parties before we begin? I'll just pause for a moment, see if anybody shouts. I'll take that as a no. So if I could ask Mr. Phelan, please, to outline the case for us.
Thank you, Chair. Good morning. Today's application is made by the Chelsea Food and Wine Company Limited for the variation of a premises licence at 20 Kale Street, London, SW3 3QU. The initial application submitted on the 12th of August 2020 sought to extend the hours associated with the sale of alcohol off the premises from 7 a.m. until 1 a.m. Monday to Saturday and 7 a.m. until midnight on Sunday. An additional submission from the applicant's solicitor, Mr. O'Mayloin, was received on the 1st of October 2020. In this document, Mr. O'Mayloin confirmed an amendment to the application, which now seeks to cease the sale of alcohol off the premises at 12:30 a.m. Monday to Thursday, 1 a.m. Friday to Saturday, and midnight on Sunday, with no change to the proposed start time for alcohol sales. A summary of these changes can be found on page 1 of the additional papers. No additional steps to promote the licence and objectives were provided with the initial application. However, a list of the proposed conditions was included as part of Mr. O'Mayloin's additional submission and can be found on pages 1 and 2 of the additional papers. 9 representations have been received which oppose this application. This includes an objection from the Stanley Ward councillors. A summary of their representations can be found on pages 2 to 4, with copies attached at Appendix C on pages 20 to 28 of the main bundle. This application did not detract any representations from a responsible authority. Council records indicate that the premises received 3 noise complaints in the preceding 24-month period. A summary of these complaints can be found at Appendix D, page 29. I can also confirm that no temporary event notices were received in the preceding 24 months. Finally, due to an error with the PDF file, the page numbers were not imported onto the initial report, and I can confirm that an identical version of the report has been made available for today's hearing, which denotes the page numbers in their usual place. That concludes a summary of this application. I'll leave it there for now. Thank you.
Thank you very much, Mr. Phelan. So, Mr. O'Mayloin, floor is yours for 10 minutes to make your case.
Thank you very much, Councillor. To begin, as you've heard, it's an application by the Chelsea Food and Wine Company, who own and operate premises on Kale Street, immediately next to Chelsea Green. You will have read the submissions that I sent to the licensing service earlier this month. And also the suggested conditions contained within it. Further to that, we have received a document suggesting certain amendments to those conditions, and I can confirm that if the committee were minded to grant this application, that those amendments would be accepted. In relation to the latter part of the document, there are some suggested further conditions, and I'm also pleased to confirm that those would also be acceptable, with the exception of the final suggestion, which relates to deliveries. And the only reason for that is that the times suggested fall outside the times that there are currently, in particular, early morning deliveries, for example, in relation to newspapers, etc. But with that in mind, and having read the representations very carefully, and in particular the representations made by the ward councillors, the applicant reduced the application, as you've heard in the introduction, to 12:30 Monday to Thursday, 1 o'clock Friday, Saturday, and midnight on Sunday. The reason why these hours were suggested on reflection was that they mirror the hours that the premises currently trade. So if the committee were minded to grant, that would in effect allow an extra 30 minutes Monday to Thursday and an extra hour on Friday, Saturday, and Sunday. So contained within my submissions, you will see that not only have we agreed to update substantially the CCTV conditions, but we've also looked very closely at training of staff, but also records being kept, not only in relation to the training, but also in relation to the day-to-day management of the premises itself. And you'll clearly see that not only we have the suggestion of incident logbooks, but also refusal books to be kept and to be monitored, most importantly. It is fair to say that a number of these conditions are already in place, and to get straight to the point, in your bundle at page 29, we do note that there were 3 matters raised with the noise team in relation to the premises over the past 24 months. It is, however, fair to say that all the matters were dealt with and dealt with promptly, and we would suggest that this is reflected in the fact that there is no representation made this morning to the hearing from the Environmental Health Officer or indeed from the Metropolitan Police. In relation to the proposed conditions, of course, they tighten up quite considerably any potential for noise in particular emanating from the premises themselves or from customers. It is correct to say that we do not accept that these premises are the root of the problems that occur and have occurred on Chelsea Green. It is without hesitation our view that those that do frequent Chelsea Green add nothing whatsoever to the area, and in fact cause our premises difficulties, all of which have been reported by ourselves, not only to the council officers, but also to the Metropolitan Police. These, I'm pleased to say, have all been investigated, and we have crime reference numbers in relation to them. But suffice to say that nobody who loiters on Chelsea Green is served in any capacity by these premises, not only in relation to alcohol, but also in relation to other goods, in particular food or cigarettes. The fact that there is no representation made from the Environmental Health Officer or from the Metropolitan Police, we would suggest should weigh heavily on your minds when making a decision in relation to these premises. In relation to the proposed conditions, we would suggest that these clearly promote the licensing objectives, and they add another clear layer of control in relation to them. There is no evidence whatsoever has been put forward in relation to the allegations raised by the residents. That is not to say for one second that we are dismissing what is clearly happening or has happened. We would like to see ourselves as part of the solution rather than being blamed as being part of the problem. In this regard, you will of course readily see that we are now happy to be involved in relation to organising meetings with residents. We already have a line of communication with the local police officer, and we have had meetings with various officers at the council. You will also note as well that part of the conditions hereby offered are that a number of the duty manager would be widely available. And of course, we are aware of the fact that there are resident associations throughout the borough. And so we could liaise with your officers to ensure that the correct chairs of the various associations in the immediate vicinity are notified of that number. But we'd also ensure that the number was clearly displayed at the premises themselves. So I know that you and your colleague will have read very carefully my submissions that deal to a certain amount of depth with your own licensing policy and the comments that we've made on the various representations that have been received. And I don't think it's necessary for me to go through those again with you this morning. But in conclusion, sir, what I would say is that the committee should feel it's appropriate that an application to vary the licence so that the hours for the sale of alcohol mirror the hours that the premises already trade, and that by doing so we promote the licensing objectives, primarily by the robust conditions that have been proposed, the history of the premises, and the very fact that there is no representation from either the Environmental Health Officer or the Metropolitan Police. So those conclude my representations this morning. I know that Mr. Rehan is online, and he and I are more than happy to answer any questions that you or your colleague may now have.
Thank you very much, Mr. O'Maloin. Perhaps I can start with Councillor Healy to ask questions, please.
Thank you, Chair. Mr. Mullen, I think what you've said is very helpful, but I'd like a bit of clarity on some aspects. Principally about Chelsea Green. You say that these premises are as much a victim of what goes on Chelsea Green as the residents. I wonder what you base that on.
We base that on the fact that these premises have been the subject to criminal damage. Most recently, there was criminal damage directed at the premises about 6 weeks ago. On a Sunday morning, someone who was wearing a balaclava went into the premises and threw eggs around the shop, and then opened up a bag of flour and threw it over goods that were for sale in the shop. Now, further to that, and it's just an example, the police were called and a crime reference number was given. The CCTV images were downloaded, and these have been sent to the police to help them with their inquiries. Obviously, as you'll readily identify, it is difficult if the perpetrator is wearing a balaclava, but nevertheless, this is not the first time that people have come into the store and caused criminal damage. Not only that, the store has also been subject to those who are loitering in Chelsea Green and coming to the store and shouting obscenities at those that work behind the counter. Some of those obscenities, to be clear, are racist, and likewise, these have been reported to the police as well.
I'm sorry to hear about that, and obviously the premises must feel under threat, but it doesn't exactly clarify what you also said about Chelsea Green. You said no one who loiters on Chelsea Green relates to these premises. You just described instances where they do relate to your premises, though obviously not as the perpetrators. But how can you say that nobody who loiters on Chelsea Green has anything to do with your premises?
Well, what I mean by that, to be absolutely clear, is that the people who loiter on Chelsea Green are not our customers. They are people who are in Chelsea Green who caused issues not only for residents and not only for us as a local business, but also for other local businesses. So to the extent that they are clearly a concern for us, and they are clearly in that way indirectly related to us because they cause us the issues and problems that they cause. But it should be very clear that we, as much as the residents and other businesses, have been telephoning the police and the council in relation to what happens there. But the main point is, of course, is that they are not our customers, and anyone who is there, they are not served in the premises for anything. And so this premises does not look to encourage those people who are currently loitering, more so as I understand in the summer months than perhaps now, but nevertheless the ones that loiter in that area.
Thank you. You also said that you would like to be part of the solution to the antisocial behaviour that does go on. Can you expand on what you mean by that?
What I mean by that is by being part, by engaging more, I suppose, with the local community and trying to have a joined up approach to resolve the issues that are there. And it seems to us as a business that by the police, the local authority, the residents association and local businesses working together, that is going to address the issues better than us as a business going down one route, perhaps residents going down another route, and the statutory authorities going down another route. If there's a joined up approach, and I think this can be demonstrated by the fact what is suggested by your own legal officer about having meetings, having a dialogue, and by pooling experiences together, then I think that the local authority, in fairness, would have a clearer picture as to what precisely is happening and what those concerns are, and then we can move forward together in that regard.
Okay, thank you very much for that. Could I turn your attention to Appendix D, the complaints against these premises? The first one is, I think, slightly alarming. The premises were found to be selling alcohol until 1 a.m. So you're already doing what the original application was asking for. Has that stopped since that occasion, or how can you tell us that the premises will obey the licensing rules?
Quite clearly, as you've identified, so what happened here was it was a mistake. It was fully investigated by the officers. They looked at various parts of the CCTV, which demonstrated that indeed it was a one-off. It clearly shouldn't have happened. The member of staff that allowed the purchase clearly was disciplined. It was felt that because of the background, as it were, in relation to this specific incident, that it would warrant a letter rather than anything further. And in relation to the what was proposed in terms of training and in terms of the internal disciplinary procedure that was taking place at the company, it was left that the officer at the council was satisfied the matters had been fully addressed.
Thank you very much. That's all.
Thanks very much, Councillor Healy. Mr. O'Malley and I have a handful of questions as well, and I'd like to start with your offer about dropping the playing of recorded music. Could you clarify for us what timings you're dropping that from, please?
So if you're minded, I mean, just to be absolutely clear, at the moment, the shop has, I suppose, what we would refer to as incidental background recorded music you might get in a retail unit. Having read the letters, and what we appreciate is that at 11 o'clock, even if music is quiet, particularly in the summer months, if someone is sleeping and their window's open, no matter how quiet that music may be, it could filter up. So what we're suggesting is that there would be no music played at the premises.
Thank you very much for that. Let's write that point down. And secondly, Mr. O'Malley, you didn't take us through the arguments for extending beyond midnight. And I mean, bear in mind the borough does have a midnight policy, and therefore we're looking for, you might think, exceptional reasons why we should extend a licence beyond midnight, and noting that there are no premises with an off licence in the immediate vicinity on the map with a beyond midnight licence. Perhaps I think it would be helpful if you could expand on your application in that regard, please.
Yes, of course. So just looking at your own report at page 50, and of course the recommendation that it is midnight closing. The hours sought, of course, now under the application are before midnight, Monday to Thursday, and obviously Sunday. So it is the extra hour on Friday and Saturday. At 12.1, and in the policy itself, it obviously recognises the fact that whilst there is midnight, there are certain stores in the borough that trade later, and indeed certain stores that even trade up to 24 hours a day. It is also correct to say that within the government guidance, and I think even within your own policy, that it is often felt that the sale of alcohol, if it is later, should be on the basis that it mirrors the hours that the premises trade. As I've said, the premises currently on both Fridays and Saturdays trade until 1 o'clock in the morning. What we would suggest is that as the premises are already open and they are already trading, the fact as to if they are to sell alcohol cannot be said that there would be any increase in relation to potential public nuisance or crime and disorder, bearing in mind that the premises are already trading. And in fact, we would also suggest that the customers who may be coming to the premises after midnight are precisely the same customers that are coming there in any event. It is, of course, the case that if the committee were minded to grant, it is not then that message is not sent out to everyone in the borough saying, look, these premises are now trading until 1. You can get your alcohol here. This is really a matter of as much to do with the internal management of the premises and to simplify things internally, but it also at the same time recognising the fact that if you're minded to grant, there is a whole tier of extra conditions that would be added to the licence that we would suggest would address very clearly and very robustly any concerns that residents have. And just looking at the sheer numbers of conditions, in my original submissions, there were an extra 14. This morning, there's an extra 3. So an extra 17 conditions, all of which
Mr. O'Malley, you've just frozen.
The venues and have been demonstrated to work. So with all of that combined, we would suggest that the committee can be confident that if you were minded, in particular, to allow the premises to trade until 1 o'clock on both Fridays and Saturdays, that the licensing objectives would be promoted.
Thank you, Mr. O'Malley. And you did freeze for about 10 seconds just after you made the point about the extra conditions, the extra 17 conditions. But I think I certainly got the gist of what you were saying, and I heard the vast majority. And I see Councillor Healy's nodding, so I'm happy that we proceed and don't go over any of that ground again. But can I just clarify, and I'm sure this was just a slip, but you said that Monday to Thursday it was before midnight, and yet the application, the revised application, is midnight 30. Is that correct?
Sorry, yes, that's absolutely right. What I meant to say was it's midnight Sunday, midnight midnight on Monday to Thursday. That's correct, sir. Sorry. Thank you.
And obviously we will treat the application on its merits. I think I need to say that. Final question, I think, is the extra conditions. There was one on deliveries, which I need to call up that you weren't happy with. Let me have a look at that and ask you why the delivery one wasn't acceptable to you.
It's only in relation to the hours. You will that the premise was currently open at 6:30. It's your typical. Well, you've actually seen the outside of it, so it's your typical neighbourhood general store. The very nature that it opens at 6:30 means that there are deliveries, notably newspapers, that will come before that. So. I appreciate that the suggestion of the hour of 8 o'clock is in square brackets, suggesting that could be amended, but it's really in relation to the earlier hour that we have concerns. If it is a matter that the committee feels strongly about, we would ask that if a condition were imposed, that it would allow deliveries from 6 o'clock. So that we could facilitate newspapers, etc., being delivered then. But to be absolutely clear, the vast majority of deliveries, like with most retail units, arrive mid-morning.
Okay, thanks very much, Mr. O'Malley. Those are my questions. I'd now like to ask Ms. Le Mesurier if she has any questions.
Thank you, Councillor. So I just wanted to clarify, it was just the delivery condition, not the refuse and rubbish condition that you had an issue with.
And to be fair, it wasn't really the delivery as such. It was more the hours that might be suggested in relation to that condition.
Okay, and just to reiterate what Councillor Hammond said in respect of surrendering the playing of music. Sorry, was that for the whole of opening hours, or was it for the proposed extended hours?
We'd be happy to for the whole of the proposed hours. I mean, for the
all day, basically. Yeah. Stop it. Full stop.
That's correct.
Thank you. That's all. Then, Councillor.
Thanks very much indeed. So, Councillor Pascal, it's your opportunity now to ask questions of the applicants. Obviously, you'll know the procedure anyway, but you'll make your case later. But do you have any questions for the applicants?
Yes, I wanted to ask how the applicants propose to participate with local businesses and residents in detail, not just to provide a number, but how they propose to contribute to the team effort in managing the Chelsea Green.
So, like with other premises in the area, what we would suggest is the starting point would be to liaise with the relevant officers at RBKC and of course, the ward councillors, goes that saying, to ascertain the contact details of local residents associations. If there isn't a local residents association, to deal with individuals who clearly are more engaged with certain matters than others. But by engaging primarily with those and also with the ward councillors, the starting point on that would be by having not only telephone numbers but also email contact details. Moving forward then, it would be clear that a meeting would need to take place, and that this is what is in fact suggested in relation to some of the proposed conditions. We'd be more than happy to be actively engaged in those meetings and to obviously liaise closely with, as I say, the local residents and with local businesses, so that we are all singing off the same hymn sheet, and that what is happening there is detrimental to our business in much the same way that it is detrimental to the peaceful enjoyment of people's homes. It is something that we very much want to resolve, and it seems to us that we can be part of that. We could also act as a force for good in terms of trying to encourage other businesses to take an active part. And finally, just in terms of the practicalities, regardless of what happens today in relation to this particular application, these premises, as you're aware, do operate late into the night in any event, and we can, through our staff, act as much not only as the eyes and ears for our own business, but the eyes and ears for the local community as well, in terms of trying to ensure that what perhaps is taking place there isn't taking place, and that there is a funneling method for reporting issues in relation to the green, and a funneling of ideas as to how the concerns can be addressed. It seems to us, and I've discussed this at length with my clients, it seems to us at least that those that frequent the green fall in primarily into two categories. I hasten to use the word youths, but younger constituents who are, for want of a better word, hanging around in the evening, and then those who, for various reasons, have certain mental health or social issues. So it needs a joined up approach. That it's, when at the moment, we're dealing probably primarily with the police, to a lesser extent with the local authority. But I think the third tier that also needs to be engaged are actually social services as well, and to get them on board, as well as the other authorities. Because without all of it being joined up, we're going to be going around in circles, and the issues that are experienced are never actually going to be addressed, because, and we accept this, that each statutory authority has their own remit and their own particular concern that they will want to address. For example, the police will be crime and disorder, but scraping in and looking at the underlying concerns here. Clearly, there are matters that we're engaging with social services. There are matters that perhaps we should be engaging with relevant officers who have particular remits for youths in the borough. And these are matters that currently, for all the best reasons, aren't necessarily being looked at in any detail, because everyone is looking at the problems after they have been caused, rather than trying to prevent the problems from being caused in the first place.
Thank you very much for that. I'll come back as Councillor Hammond during my presentation, but what I would observe is that this is a very good statement that's been made, but it reflects what has actually been going on now for a number of years to attempt to address this problem. And part of the problem is how the problem is fed, which I'll return to later. But
is that a question, Councillor Pascal?
No, it's not a question. It's just a note. I've noted the smelling of coffee.
Do you have any further questions?
No, I don't have any further questions.
Okay. Well, thank you very much, Mr. O'Malley, thank you very much for your submissions and answering the questions. And I will now turn to Councillor Pascal to make your submissions, and you've got up to 10 minutes.
Okay, thank you very much, Councillor Hammond. As one of the local councillors, I've been councillor in Standing Ward for 10 years, and alongside now Councillor Josh Rendell, who's been leading on this matter for the ward, and also Councillor Taylor Smith, who's the deputy leader. You will have seen our joint letter of objection, which is tabled in the papers, so I won't read it out as a whole. But if you turn to, I think it's titled Appendix C, it has the phrase in the second paragraph, heavy use of alcohol for the past 2 years. Third paragraph, caused great distress to residents right around the green. And then further down, we object on the following grounds. The buildings surrounding businesses, Chelsea Green, are residential with many families. And the noise created by customers entering in early hours in such a residential area will cause an issue, especially there's so many residential homes and retirement home on the Sutton estate. There have been evidence of alcohol purchased at the store being used in the past for some events on the green that my colleagues have. There has been noise, nuisance and crime, mostly antisocial behaviour, happens most evenings. Local Standing Ward police are very aware. We have a large post bag as Standing Ward councillors. Not all of these things that are reported are going to become official noise nuisance reports, although there are 3 of those. And we believe that any extension of licence would exacerbate this issue, which is causing great distress and noise to local neighbours. So that was from that letter. These premises that we're talking about today are located within the footprint of the historic Sutton buildings, forming the northern boundary of the Chelsea Green. And we're delighted that the Clarion has decided to refurbish the estate and bring back into use the 4 mothball blocks. To the southeast of the green, there's also a large mixture of ground floor retail and upper floor residential. Chelsea Green has recently officially been accredited as a name on the GLC map, reflecting its renaissance as a local village centre of interest. As standing councillors, we are not teetotalers, and we do support local businesses during this terrible affliction of COVID. However, Chelsea Green has had a continuing instance of antisocial behaviour, largely late in the evening, around drinking on the green and surrounding pavements. As local councillors, we have a postbag of complaints from local residents and associations. And the police are aware, but as they are so stretched, they're only able to attend when there are major instances. Now, we do appreciate there needs to be a balance between what businesses need in terms of opening hours and also what residents require. And looking through the guidance notes of this committee and the objectives of licensing, it is evident that the hours of 11 to 12 are considered hours to be when things wind down, when noise levels, background noise levels go down, and also residents particularly need the availability of sleep. There are large numbers of children who've just recently returned to school, and there are lots of people who are trying to work long hours and get their businesses resuscitated and need to set off early in the morning. We welcome that Chelsea Food want to become part of the solution, and we would hope that in the future they do participate in the activity that's already been happening around the square with other businesses and resident associations. I've attended 2 meetings recently on the green with local community and businesses, looking at how there might be better management of the green, how businesses might run their premises better, how they may communicate with each other and pass on details of miscreants and issues, and how to use new tools that the council has got to do with CCTV and street wardens, and the use of the local development tax, NSIL, to reinforce these measures. We're also working to look at how we can improve the traffic management, refurbishing the green, and working better in better integrated way with the police. There's a very good integrated working with the police through a weekly tasking force of tasking meeting. However, the police are increasingly stretched and have emphasised that they can only come on specific issues. Now, we do not see that how extending the hours of off sales in particular are part of the solution. However well managed they are, they can only add to the alcohol load in the local area. The 2 committee objectives that I would focus on were disorder and nuisance. And there is a fundamental difference between on sales and off sales. By definition, on sales cease when the hour of the time limit comes. Alcohol has to be consumed before or left at the premises that it's been bought at before the closing time. Off sales, on the other hand, are purchased specifically to be drunk off premises and to be drunk after the purchase time. And there is a fundamental difference, therefore, to off sales and on sales. Our conclusion is that however well managed and however well intent the management of Chelsea Food and Wine are in their application, and however much they say they want to participate in a process of getting together of the local community, which has already happened for a number of years, that our request is that this license extension does not, an extension of hours does not contribute to the solution, but only makes the problem more difficult to manage and to solve. And therefore, we as 3 ward councillors strongly support local residents in asking that this application be turned down. Thank you.
Thank you for your submission, Councillor Pascal. We've now up to questions from the committee members. So, Councillor Healy.
Sorry, I was just unmuting. Councillor Pascal, how do you answer the applicant's position that the people who caused disturbance on Chelsea Green are not his customers?
I certainly don't believe they are in all cases, and I think the analysis that was given about there being a variety of types of people who've caused problem on the square, on the green, is correct. And I also agree with the fact that this is a partnership exercise. Our proposition, therefore, is not an absolute one that all the problems on the green are caused by this particular premises. but selling alcohol later in this location will add to the alcohol load in the local area for consumption after the time of sale. And it is a balance to be struck. As I said, we as three councillors are not teetotalers and we're not anti-business, but we just think the movement in the direction of selling alcohol later will put more alcohol into circulation in the local area and will add to the problem that needs to be managed rather than reducing it. And therefore, on terms of a balance, I don't see how this application becomes part of the solution. I think it will add to the problem to be managed.
Okay, that's all. Thank you.
Sorry, if I could add to that, that it also goes beyond the council's general policy that outside town centres, I believe in certain specific areas which are defined, but I don't have them in front of me, as to basically alcohol sale should be restricted before 12 unless there are particular circumstances that come to play. And I think that's in the guidance for your committee in any case, and you'll understand the details of that better than I do.
Indeed, thank you.
Was that it from you, Councillor Healy?
Thank you.
Thanks very much. Okay, Councillor Pascal, I have a few. As I've got your objection open in front of me, I'll start there. Third bullet down, you say there is evidence alcohol purchased at the store has been used in the past for some large events on the green. The only evidence I've seen is of the 3 noise complaints from 2020, which we've discussed earlier. Can you tell me what the evidence is, please?
I can't. What I must admit, Chairman, is that I've been asked to stand in behalf of Councillor Josh Rendell, who, as I said, has been leading for this in our council, but I'm sure that could be provided. What I do know is, in terms of postbag from residents, that I and both the other councillors have a continuous complaints from residents. And in fact, in the supplementary paper that was presented today, you can see one of them.
And to what extent does that postbag and complaints of noise explicitly link the noise with the Chelsea Food and Wine premises as opposed to general noise on Chelsea Green?
But if I could take that in 2 parts.
Thank you.
There is no preponderance evidence that the majority of noise caused on the green, as you've stated, comes from the activities of Chelsea Food and Wine. What I'm saying is that the preponderance of evidence that we have is that noise late in the evening, when it causes disturbance to residents, has largely been has been to a large degree exacerbated by alcohol consumption, and part of the alcohol purchase in the green is to do with alcohol purchase from Chelsea Food and Wine. Now, what we're arguing for here is that increasing the hours of licensing, unless there's no purpose of selling further alcohol, but if there's a purpose of selling further alcohol and selling it later, that it's only going to add to what we would call the alcohol load locally. So we would resist the extension of alcohol selling off sales licenses in any premises around the green, because we believe that what we should be doing is reducing the availability of alcohol locally, and that is a major component in the disturbing instances that happen on the green. It's not the only one, and this does require, as was presented earlier on, and we welcome that presentation, a team effort. But the team effort has been going on, and one of the difficulties we've had is the fact that there's been too much alcohol load locally, and therefore we would be arguing the balance, particularly for off sales. As I said, there's a difference between off sales and on sales. If there was an on sales issue with a premises where people were consuming on the premises and people spilling it out to cause problems, that would be tackled directly with that premises. The issue with off sales is that consumption of alcohol only starts once the purchase has been made, and we think making more alcohol available later is adding fuel to the fire rather than taking away the fuel from the fire and making the fire easier to put out and manage and put out.
Thank you very much. You've talked extensively about the problems that your constituents have reported in the evenings. What do you think about the extension in the morning from 8 a.m. and back to 7 a.m. as a start time for the licence?
That is we see as less of a problem. but it still plays into the same mantra of but into a lesser degree, that selling more alcohol for more hours means there's more alcohol around.
Okay, and you've said that both public nuisance and crime and disorder, those two of those four licensing objectives come into play, but most of what you've talked about has been public nuisance, and particularly noise on the green. Could you say a bit more about why you're saying the crime and disorder is active?
Well, it's debatable as to the thresholds between noise and nuisance and disorder. I know there are legal definitions, but to our residents, there's not much. And also, the other thing is that when some of our residents have gone out onto the green to try to remonstrate with those who have been making a lot of noise, that they have been threatened during that process. Now, to date, there hasn't been enough evidence to substantiate that in terms of a crime being committed. But one of the things that we are looking at as local ward councillors is as to whether we can organise, as you will be well aware, Councillor Hammond, wearing your other hat as a local ward councillor, there is a process going at the moment looking at whether we can further expand CCTV and ward wardens to bring to bear into this exercise. I think the solicitor for the applicant articulated in many ways quite clearly some of the issues that we're all addressing. But to date, we haven't had any active participation from that particular premises or that particular company's management in that exercise. And this has been a very large postbag for us as councillors and has involved the local police, residents, and we have had involvement from social services and all of those other agencies that he mentioned. Now, what we're saying is that in the balance of things that need to be addressed, the problem that needs to be addressed in this square, alcohol is one factor. It has caused the raising of temperature, if you like, around from what might have started off as a minor nuisance thing to becoming noise and nuisance to becoming a disorderly situation. The alcohol helps to escalate these issues and makes them more difficult to manage. How to manage the problems on Chelsea Green is a complex interacting series of things that need to be brought to bear. Part of it, we believe, is that on a balanced basis, the control of the amount of alcohol and the time of alcohol that is sold around the green, and we believe that off sales are a problem which go later for the reasons that I suggested, that they start once purchased rather than those that are on sales which are finished at the time of closure of the license. So we think alcohol is a factor. We don't think extending this license will help solve the problem. We welcome the company's avowed intent to participate in the group activity around the green in the future. And we think the best thing would be to have earlier curtailment of sales, and certainly no later than an existing license, and that that there should be full participation of the businesses as this business has said that they wish to participate. That would give us the best chance, together with the new tools the council can bring to bear.
Just picking up on one of those points, are you saying that the terminal hour of this license should be brought forward or to be earlier than it currently is? I don't know that we have the power to do that in a review case.
I think I don't want to tell you your job, but I think you have to tackle the issue that's been presented to you by the application. I'm certainly in other committees we have to do that. But so sorry. What I'm saying is that whilst ideally, in my personal view, we should be looking at that, I don't think that's a subject for discussion today. I think, though, the subject is for discussion today as to whether the hours should be extended is the one that we're very clear on, that they should not be extended because they will only add fuel to the fire. they're not the only fuel on the fire, and you can't tie everything that's wrong with the green to this particular premises. It's not an absolute linkage, but it is that it will contribute to the problem that needs to be managed if there is an extension. We think that's a backward move, and it doesn't fit in within the borough's general policy of local shops in local areas being certainly prior to midnight.
Thanks very much. I'm glad you clarified that, because this is not a review case of the current license. It's an application, but I know one of the written objections was actually asking for the hour to be brought forward, but we've brought that point out. Could I ask? Go on,
I was just basically wanting to clarify my position as to why I'm firm about this should not be extended. By my position personally outside this particular context is that actually it would help in an ideal world for the management of this issue if it was earlier than that, but that's not a subject for today.
Understood. And could I finally ask, as an alternative, a number of conditions, 17 new conditions have been proposed either by the applicant or by the solicitor, by our solicitor. What's your reaction to those conditions? Might that be a solution to controlling the problem?
Well, I think that those conditions will all help, but I think the timing issue is the one that we're proponently wishing to address as councillors today. We do not see that making this later will help. I think also the question that there's a lot of idealism in some of the measures that have been put forward, and I think that the key phrase from the applicant solicitor has made earlier on is that it's the joining up of these issues that's the problem. And I think that we would want to see evidence of how the issues on the square are managed before we would wish to even entertain any thought of any extension of time.
Thanks very much. Those are all the questions that I have, but I'll turn to Ms. Mazurier to see if you've got any questions.
No questions for me, thank you.
Thanks very much. And now the applicant's representative, Mr. O'Maloin, do you have any questions for the objector?
Sir, I have no questions for the objector.
You are breaking up there. I can't hear you.
Sorry, can you hear me now, sir?
I can. I think we've got quite a few people who are not on mute. So if we could put everybody who's not speaking on mute and allow Mr. O'Maloin to speak.
So is that clear now?
That's much better.
Thank you. I don't have any questions. However, I have been given some time in relation to May 5th.
I'm sorry, you're actually breaking up now. I understand you've got some instructions from your client, and obviously we do want to hear that. But we are having some technical problems hearing every second word. So,
can you hear me now?
Keep pressing on, and let's make sure we've got all the cameras and all the. In fact, try turning your camera off as well and just speaking, and see if that works.
Right, camera off. That better?
I think it's better.
Okay, we'll get there in the end. There were two. It's not. I have no questions. And I'll take forward what.
I'm sorry we've lost you, Mr. O'Maloin, but I think it's very important that we hear this. So let me turn to the technical team.
Mr. O'Maloin, I will email you the number to dial so that you can dial into the meeting and speak to us over the phone.
Okay.
So Chair, could we just adjourn for 5 minutes just while we get Mr. O'Maloin connected again?
Yeah, we'll adjourn and just hold here for 5 minutes.
Thank you.
And I think we better put the adjournment notice up on the screen for the public to see. But the Teams meeting does remain live and recording, so please keep all the microphones on muted around the room.
Thomas O'Maloin
is now joining.
Hello, Mr. O'Malley. We've got you back in the meeting now. So
hi. Can you hear me? Okay.
Yeah, we can hear you very clearly now. So Councillor Hammond, whenever you're ready.
Okay, thanks very much. I'll just do a quick check that Councillor Healy's still with us. And great. Okay, in that case, Mr. O'Malley, please go ahead.
Thank you. My apologies for that. So as I was saying, we don't have any questions for the councillor, and we fully take on board what he has said on behalf of the other ward councillors and himself, and also the residents. And regardless of your decision this morning, we will be making headway to start the process that we've discussed at length this morning in any event. But further to that, and so as to try to give more assurances to those that raise objections, my clients are able to confirm two more matters. The first is that they're happy for their CCTV to cover the outside area of their shop, which they would say that would assist in acting as a preventative measure for crime disorder, and in particular to those that are causing issues on the green itself. But secondly, and perhaps more importantly, if you were minded to grant that this application would be time limited to 1 year. What has become apparent is that and I think that the councillor touched on this, looking at the evidence as to what may be and what we as a company may do. So what we are now suggesting is quite simply that if you were to grant that, the grant would only take effect until the 6th of October 2021, and that during that period, all of the extra conditions that have been suggested would be attached to the licence. What we would hope, obviously, would be that during the course of those 12 months, whilst we are engaged with all the interested parties, that they can feel confident that we would need to go back to yourselves to request for that variation to be made permanent. So I hope that is received, but it's given with the very best of intentions and trying to find a middle ground, as it were, between the business. I appreciate it's not a licensing objective, but I do know as councillors, and I am I'm also obliged that those that have raised concerns are obviously aware of the very real struggles that all businesses are finding themselves in. So on that basis, the application is hereby amended, and that is all I wanted to say.
Thank you very much for that extra submission, Mr. O'Malley. And I'll turn to my colleague, Councillor Healy, to ask if she has any questions on that. And I'll come to Councillor Pascal presently, but I need to go through the committee first.
Apologise, I was muted. No, I'm quite happy with what's been said. Thank you.
Thank you. I don't have any questions on it either, and I'll ask the legal officer if she has any questions.
Thank you, Chairman. I just wanted to clarify if obviously A, if you're minded, and B, if you're minded to go down the time limited route. If you're going down the time limited route, I just want to clarify that all the conditions that you might add today would fall away at the end of the time limited condition, and obviously it would revert back to the initial license and the initial license hours, and obviously a new application would be made. I think I just wanted to check that if we were going to go down, or you were minded to go down the time limited route, would I'm presuming the issue of the music playing would be a time limited offer as well. Is that correct, Mr. O'Malley?
Yes,
that's correct. And also, you've just mentioned about the CCTV covering the outside area. You would be happy for an additional time limited condition, or if we go for a permanent license, permanent condition to be added regarding the CCTV covering the outside area. To what extent of the outside area are you thinking? Just the pavement or the green, or?
The way that the cameras can be angled, etc., would be the area outside. So it's the pavement running obviously immediately in front of the store, but also running down the street itself.
And not on the green though, just along the pavement in front of the store and along the street. Sorry, is that correct? So I can't hear you. Okay. And sorry, Councillor Chairman, is it okay if I just clarify some of the conditions generally at this point?
Yes, we can do that now. I need to bring Councillor Pascal in to both ask questions and to comment, and to offer him the opportunity to comment. But
it's up to you. I can do it afterwards if you like.
It's only a very short one.
Well, go on then. Let's have Councillor Pascal now then to both comment on that extra submission and ask any questions if you wish to.
Okay, I mean, I think there's two short points. One is that we stand by our objection, even though it's been modified, and we thank the applicant for the modification, but we don't think that addresses the issue. And the issue of CCTV, I'm not a technical legal expert on CCTV, but I do understand that showing a private or business private camera onto public premises, that there are legal difficulties in either that being done or any recordings are made, which would need to be clarified before that was weighted within a decision that this committee made.
So on that point, briefly, Councillor, if I may, I can address that. The reason why, and Councillor, you're absolutely right, there are legal difficulties if cameras were to be pointed from this premises onto Chelsea Green, which clearly is a public area. However, cameras that are pointed to the area immediately outside and the footpath leading to the premises, that is permissible because you could show a link between the premises and the areas in question. Hence, the actual reason why the suggestion was that the CCTV would be limited to those particular areas.
Okay, thanks. And Councillor Pascal, do you have any comment on that?
No, I couldn't either accept or refute that. No disrespect to the applicant's solicitor, but I just don't have the knowledge to opine on that. Perhaps he does, but I think that officers would need to be careful in briefing you on the situation of how much weight to put on that offer. That's all I'm saying on that one. But we come back to the fundamental thing is that we believe that we should not be extending the sale of alcohol times on this green at this time.
Okay, well, thank you very much for that. So I'm now going to turn to the legal officer, Mr. Le Mesurier, to offer any advice and also to go through the conditions. So the floor is yours.
Thank you,
and the rest
Chairman.
of us will go on.
Mr. O'Malley's confirmed that the CCTV would only be directly outside the shop and in the pavement leading up to the shop and not on the green, so that probably deals with that issue. I just wanted to check, obviously the proposed conditions as offered by the applicant and as added to and tweaked by myself, they've been distributed to the parties in advance to save time now. And I just wanted to check with Mr. O'Malley that he was, I mean, obviously we discussed the delivery condition and he just wanted to change the time, but is he happy with all the other conditions as amended in red by myself?
Yes, correct. I think I'm happy with the amendment.
Okay. And obviously the only other possible, if the committee were minded to grant, the only other possible conditions would be the time limited element and obviously the CCTV, which you just offered as well. Is that correct?
That's correct.
Thank you. That's it, Chairman. Thank you.
Thanks very much indeed, Mr. Mazirier. Do we have any final comments from the licensing officer, Mr. Phelan?
Nothing from me, Chair. Thank you.
Okay, well, thank you all very much indeed. The panel will now retire to our other room and we'll meet there at 20 to 12, so 11:40. That's the end of the hearing today. Governance will notify the parties of our decision within 5 clear working days, but the full reason determination will follow later. So thank you all for your representations. Today the hearing's closed and the live broadcast will end.